but the weather seems to deter people for some reason. I'm very happy that you did not allow it to deter you because the information that you'll receive today is going to be very beneficial. Just a little bit about universal dementia for those of you that don't know us, but I've seen many of you before. We are a nonprofit focused on caring for caregivers. Caregivers that are in general, but specifically also caregivers supporting loved ones living with dementia. And I want you to know how important that is because right now we spend a lot of time caring for the loved one living with the disease, which is absolutely necessary. But also we need to spend more time caring for the caregivers. Caregivers die at a rate of 30% before, 30% of caregivers die before the loved one they're supporting. And let me just ask you the question, why do you think that is? Stress. We forget about ourselves. What'd you say, ma'am? Not taking care of ourselves. So one of the things we emphasize is focusing on making sure we care for you. And so we make these luncheons very special. So I hope you feel special today. That somebody else bought you lunch. But feel special, but also not just lunch, but the opportunity to connect with other caregivers and the opportunity to gain a lot more information about the topic of caregiving, which is important. I want to make a few announcements. Before I do that, I just want you to know I'm in this because of the work I did with my mom and dad, both of whom had dementia at the same time. And so I had the gift challenge, or whatever you want to call it, but it turned out to be a gift and a blessing of supporting them through their journey with the disease. So we've been in business about 10 years now. A couple of announcements. There's some things happening that I want to make sure you know about. There is a project called Building Brain Wealth. It's targeted at African American men, and it's focused on, it's a group from the University of Michigan that we've partnered with, and we have a day coming up on June the 7th where we are focusing in on brain health and how to keep your brains healthy. And so I'm going to put the flyers on one of the tables, and you can come and take pictures of them so that you would know the dates and times of them. But the topics they'll cover 4 basic topics. All the presentations are by African American men. Women, you're invited too. Just so happen, because we have brains too, right? But we want to make sure that men are targeted to make sure they know how important brain health is. Another group in particular, St. Pat's, many of you are involved with them. St. Pat's is starting an entrepreneurial program. So those of you that have that special talent and time, please look at these flyers related to the entrepreneurial program they're putting together. Our boot camp is May the 31st. If you're interested, I'm in the back, and I'll get you signed up for it. It's a full day, and it's at the Carhart Center downtown. And we spend a full day talking about educating, experiencing, and learning. And all the materials are free. Every event we have is free. The last one that I'd like to talk about, the June Lunch and Learn. Please be here. We have a neurologist coming who is going to walk us through the steps they take in making a dementia assessment. And I have asked him to talk about what information you should leave with. Because too many people, and folks of color that I know, have spent time with their neurologist, and when they left, they weren't sure what they got. That was a waste of time. If you didn't walk out with the information because you didn't know the questions, I'm preparing a list of questions that you should ask or recommended that you ask in those kinds of places. We need an assessment in order for us to know how to treat your loved one. So please come to that. And then the very last one is the Wayne County Senior Fun Fest. It's on Saturday, June the 14th from 11 to 2, and it says rain or shine. It's ages 60 and up. And they have picnics and food and talent and exercise and bingo, other activities, and all the resources are free. I was told that if there was a group of 20 that wanted to come over and sign up, they can pick you up here. That way you don't have to drive down to, where is it, Hines Park? If there are 20 of you that want to ride together, they'll pick you up here and drive you down there, and that way you can just leave your car in the parking lot. okay? Other questions? We have some giveaways that we'll do at the end, but I am excited and very pleased that with our guests today. They are no strangers to us, even though they've been part of our group since the beginning. They provide us with all kinds of information about the legal issues, because I know my lane, and I got a legal opinion, but that's all it is. But when you go to experts, you get the real information. And information that I know that you need is all related to power of attorney, in addition, legal, financial, as well as general. You need information about what people want. Let me ask you, do you want someone else making decisions about how you die? Wouldn't you like to leave a document on record to talk about how you want to be treated? Do you want to be resuscitated? I don't know. You need to have those answers for yourself. And they will give us opportunity to think about this, as well as estate planning. Elder Law and Advocacy Center, and we have 3 guests. Who's first? Okay. You can give your own introduction. How about we'll give them some love and welcome them to Universal Dimensions meeting.
Thank you so much. And thank you all so much for facing the rain today to be here. We are the Elder Law and Advocacy Center, which is a division of Neighborhood Legal Services, Michigan. And I am going to be covering a couple of housekeeping things. My name is Aubrey Ortel, and I'm a law graduate working with the Elder Law and Advocacy Center. So you all should have a blue folder in front of you. If you do not have one at this time, would you please raise your hand? Looks like everyone's got one. Great. Okay, so in this folder, there is a copy of our slideshow presentation today. So we ask that you follow along with that. If you have any questions, we ask that you hold them for the end. And you can make notes on that slide deck, and any comments or questions you can write down there as well. The other document that I want to draw your attention to is called the ELAC intake form. It looks like a page with a bunch of boxes to check. That is the most important form in that folder. That's how we get connected with you for services. So if you are interested in moving forward with any of the legal documents that we talk about today, we ask that you fill that form out and make sure that one of the 3 of us have it before you leave today. And if you do fill it out and give it to us by the end of this session, I have some worksheets for you to take home to get the process started right away. And so without further ado, I'm going to hand it over to our attorney, Antonia Harbin, who's going to get us started on the life and legacy planning documents.
Okay. I don't know if it's good afternoon. It is almost afternoon, so good afternoon in 4 minutes here. I'm Antonia Harbin, and we're just going to talk to you quickly about life and legacy planning today. We're actually the Elder Law and Advocacy Center, briefly established in 1996. We're a division of Neighborhood Legal Services, Michigan, and we help those who are 60 and older who live in Wayne County, as well as caregivers. So I know that a lot of you are caregivers today, and we can assist you with a variety of things, but today we're going to talk about those very important documents that you need to be a caregiver, as well as those documents needed for your care recipient. We have funding through Detroit Area Agency on Aging, but our program today is funded through the City of Detroit, and we have other funders as well. And if you're interested in other services, we'll be around later to talk about that. So today, the Life and Legacy Planning Program, this is a program that, like I said, is funded through the City of Detroit. There's some criteria to be approved for this program. Basically, you have to be a City of Detroit resident, own a home in the City of Detroit, and earn up to 300% of the poverty level to qualify. We also have our traditional program where you have to be 60 and older, live in Wayne County, okay? There's another part of this program about probate legal services, and if you're interested, know someone who's living in a home and maybe it's not properly deeded to them, it's grandma's home or someone's home where people have been living there, but they haven't really deeded properly. There's another part of the program we can tell you about as well through the Gilbert Family Foundation. So quickly, I am going to talk about life planning and legacy planning. And what a life plan does for you is it helps you to prioritize what's important to you based on your own priorities. And then legacy planning is the act of how you're going to prepare your property, your assets, your home, and who you're going to leave those things to upon your death. So we're going to talk to you about some very important documents. I'm going to speak about the durable power of attorney for finance as well as the durable power of attorney for healthcare. Those are known as life planning documents, okay? So they're relevant while you're living. And then my colleagues are going to talk to you about the last will and testament, ladybird deed, and trust, okay? So life planning documents are very important. Like I said, they're relevant while you're living. You're able to remain in control while you're alive. And what they allow you to do is choose an agent under a durable power of attorney for finance. You're choosing that agent that you trust with your life, or under the durable power of attorney for healthcare, you're choosing a patient advocate that you trust with your life. And when or if you're not able to make those important decisions about your finances as well as your health care at a certain point, those chosen agents, they will step in for you. They will make those important decisions for you. And what people don't realize is that without proper legal authority, you can't just simply act on behalf of someone else. So as a caregiver, your care recipient has to give you that power so that you're able to act on their behalf. But it's also important as being a caregiver that you want to have these documents in place so that someone can act on your behalf. We heard Dr. Duran say that, a lot of times caregivers are at risk because they're doing a lot of work, helping out, but they need that assistance as well. So if you don't have these documents in place, if you don't have a durable power of attorney for finance, you don't have one for health care, who's going to be in charge? Well, the probate court judge is going to be in charge. That the probate court judge can determine if you will have a guardian or a conservator, okay? We've all heard of some of the, different celebrities in the media that have undergone guardianship, conservatorship, and they're not in control of their finances, of where they live, because these decisions have been stripped from them. So with the guardian, actually a guardian is over your medical care treatment decisions. And that guardian can tell you where you're going to live, okay? They can remove you from your home, place you in another location. They also can determine your end-of-life treatment decisions, so determine if you have life-sustaining treatment or not. And a conservator is over your assets, your real property, okay? So that person determines how you're going to spend your money. If you're going to have a home, they can sell that home. So these are very important decisions that are stripped away if you don't have these documents in place. That's why we're communicating the importance of them. And really, anyone starting age 18 can have these documents in place for them, okay, and should. As well as, let me just tell you a little bit more about the durable power of attorney for finance. When we draft our documents for you, if you're qualifying for any of our programs, and I'm sure you qualify for, one or the other, you may, but basically the agent that you've chosen is immediately able to act for you. Once the document is signed, that person can step into your shoes right away, the next day, the next hour, whenever. But you are the principal, so you're able to remain in control until you're no longer able to give informed consent. There's also another document known as the springing power of attorney for finance. And that document actually becomes effective when an event takes place, an accident, some emergency event has to take place. Then two doctors, they have to agree you're no longer able to manage your finances, and they have to put that in writing. Okay, so that's when the springing power of attorney for finance takes place. We want to let you know that if you were doing these documents, and this particular one, the durable power of attorney for finance, if you were going to a private attorney, you would pay about $250 just for that one document. But with this program, it's free to you, okay, if you qualify. And then with the durable power of attorney for finance, your agent that you've chosen is going to have the legal authority to pay your bills, access your bank accounts. This person can sell your real estate for you. They also can apply for public benefits like Medicaid for you, as well as assist you with a litigation if you are being, anything that you needed in terms of that, defending a lawsuit, starting a lawsuit, file your taxes for you. If you had a trust, they could help you manage that trust. So you can see these duties are broad and narrow. So that's the kind of spectrum that the actual durable power of attorney agent has. They could perform very small duties or very large duties for you. And with the durable power of attorney for finance, we spoke about many benefits already, okay? You're remaining in control. You get to choose that agent that you trust. That person steps into your shoes when you're unable to make those important decisions. Also, you're avoiding court action. You're avoiding that judge being able to make those decisions about guardianship and conservatorship for you, so you're avoiding guardianship and conservatorship. Also, your agent is not individually responsible for your debts. So your agent is protected under this document as well. But you also are protected, because if your agent does mismanage or does something improper, they could be found liable in court for that. And one additional benefit to this document is it avoids joint accounts. And when we say joint accounts, we're talking about putting or placing another owner on your bank account, So we say generally joint ownership is bad unless it's between a partner or your spouse. Those situations are okay. But if you're thinking about placing a daughter, a son, maybe a friend on your bank account, you want to think twice before you do that, okay? A lot of us may think, if something happens to me, what am I going to do? How am I going to manage my finances? Well, you know what? I'll just put my son or daughter on my bank account. That way they'll have access to my bank account. They can pay bills for me. You don't want to do that, and you don't have to do it if you create the durable power of attorney for finance, okay? Basically, you can lose control over your finances because the perception is that now that joint owner, whoever you've placed on there, that's their money as well, okay? If a creditor, one of their creditors, comes looking for something, money that they owe, then now they have access to your money, okay? And then if you're going to qualify for Medicaid, that could negatively be impacted as well. Because with the Medicaid program, they look back 5 years and they're going to see, have you given away any of your assets? Have you put a joint owner on your account? If they see that, the perception could be that that's their money. It may or may not be. And that could cause you not to qualify for Medicaid right away, which is a penalty to you, and it's called a divestment, and we'll talk a little bit more about that. Now I just want to jump into this other document. Everybody has heard of this one, the Durable Power of Attorney for Healthcare, okay? This is known as the Advanced Directive, the Patient Advocate Designation. They're always asking you when you go to the doctor or your health system, you know, do you have the Durable Power of Attorney for Healthcare? Do you have your Advanced Directive? We can scan it into the healthcare system. And they do that. So this document is really important because this one, you're going to choose your patient advocate. You're the patient, you're choosing a patient advocate to make those important decisions for you when you're unable to do so. And that could come through, you know, not having capacity or just not being able to perform like you normally would. So the type of decision making that this patient advocate can have is they can determine what kind of medical testing you have, what medicines are administered, or if you have surgery or procedure. They also ensure that your treatment plan is going to be carried out or it will stop, you know, according to what you want to happen. And they can obtain medical records for you, as well as make sure that you're getting admitted to the hospital you want to go to. Or if you needed hospice, they could enter you into a hospice program or a skilled nursing facility. After you go to the hospital, sometimes you have to go to a rehab and be there for a couple weeks. So they can actually make sure that that happens as well. When you're executing the Durable Power of Attorney for Healthcare, like the Durable Power of Attorney for Finance, with a private attorney, it's going to cost you about $250, okay? So with this program, it is a free document to you. So when can a patient advocate act on your behalf? Actually, this can happen when two doctors have determined you're no longer able to make those informed medical care treatment decisions. That's when your patient advocate steps into your shoes and acts on your behalf. And then you, as the patient, you're always able to revoke this document, even if you don't have capacity. And what I want to mention too is that with these documents, the two I've mentioned today, you have to have capacity to be able to enter into these documents and create them. So it's really important to get that started because we never know when there's a situation where we may not be able to do that. One last thing for me, just wanting to talk about who you should choose. We've talked a lot about the documents, what they cover, what the benefits are, but who should you choose? Well, you want to choose someone you trust with your life, someone that you've seen be responsible, okay, make good decisions, and you consider them good decisions. Also, someone who you can trust with, talking about finances and healthcare decisions. So that's, really a big one there. As well as someone who can follow your wishes, someone who can execute your plan for you. And then someone who has time to devote to you because there's a lot of decision making, there's doctor's appointments, there's a lot of different processes, research, different things that you have to do, and you all know about these things as caregivers. The other thing is someone you know that is physically and mentally capable to act on your behalf. So those are actually the final things that I have to say, but I'm going to introduce Irma Thomas. She's going to come up and talk about legacy planning.
Good afternoon. It is afternoon right now. So my name is Irma Thomas, and I am the managing attorney at the Elder Law and Advocacy Center. Antonia talked to you about life planning documents, and those are those powers of attorney for finance and power of attorney for healthcare. Again, those are active while you're living. Upon your death, they're no longer valid. Then we start talking about our legacy planning, and that is our last will and testament, our Lady Bird deed, and a trust agreement. Now, in regards to technology, that's not my strong point. So let's see, am I going up or down? Okay, here we go. So when we're talking about legacy planning and generational wealth, again, we're talking about our last will and testament, which is going to control after our death, a ladybird deed, and I'll explain to you what a ladybird deed is, but it's going to control during our life and after death. And then we're going to briefly talk about trust, which controls during our life and after death. So our last will and testament, most of us know what a last will and testament is. The legal term is when you have a last will and testament, you die testate. And our last will and testament is just a written document that's going to give instructions about how we want to leave our personal and our real property after we have died. So there's a misconception with last will and testament. Most people believe that if I have a last will and testament, it does not have to go to probate. It actually does. Your last will and testament is submitted to the probate court, and the probate court will review that last will and testament. They will make sure that it complies with Michigan law. And they'll make sure that every I is dotted, every T is crossed. And once they determine that it does comply with Michigan law, they will appoint the personal representative. Sometimes that person is called the executive. So the personal representative has no authority to act until they submit that last will and testament to the probate court, and the probate court issue them what's called letters of authority. So once they get those letters of authority, then they can start moving the assets. They can, what we call, marshal the assets into an estate. They can contact the bank and open up an estate, bank account. They can contact any stocks companies or, 401k and tell them, we want you to move the assets over to this person. They can change the title of, cars. They can change the ownership of homes. But until that last will and testament is submitted to the court and the personal representative is appointed, they have no authority. Now, under the City of Detroit program that we've been working with, the City of Detroit is paying us to draft those documents. If you don't qualify for the City of Detroit program, then you may qualify for our traditional program. And if you went to a private attorney, a last will and testament may cost you about $900. And again, through either one of the programs, if you qualify, it is free. So what happens if you die without a last will and testament? The legal term is you die intestate. Intestate succession in Michigan, the state of Michigan is going to identify your heir. So if you happen to be married and you die, then your spouse is going to get preference over your estate. If you do not have a spouse, then we're going to look at your children, your grandchildren, and your great-grandchildren. So it's the family tree that they look at. So I love to give the example of my grandmother. So my grandmother did have a last will and testament. I drafted it for her. But let's take her as if she died intestate. My grandmother had 8 children. So if she died intestate with the 8 children, 2 of those children had predeceased her. And so of those 2 children, one of them died when he was 17. He had no children. But one of my uncle had 3 children. So if she had died intestate, all 8 of those children would actually have received under her estate. But the one who didn't have children, since he didn't have children, then he wouldn't have 1/8 of that estate. But that one uncle who had the 2 children, those 2 children would have taken his 1/8. So you can see we would have 5 children. Well, we would have 6 children that had 1/8 and 3 children that would have shared the 1/8. But however, what my grandmother did by having a last will and testament, 5 of her children already had families. They already had their own homes. But my aunt, who was her caregiver, and also she was not married and didn't have a home, my grandmother left the home to my aunt. So by having a last will and testament, you get to determine who you want to leave your estate to, not the state of Michigan. So what actually goes through probate? Anything that's just in your name, anything that is individually in your name, and there's no beneficiary. An example of that would be a checking account. So if you have a checking account and it's not joint, there's no one's name on it, and then it will have to go through probate. Also, life insurance policies. A lot of times when we first get a life insurance policy, we will put a beneficiary on it. But sometimes, those life insurance policies, they could be 10, 20 years old, and the person that we named as a beneficiary has died. So if they predecease you and there's no one as a beneficiary, it will have to go to probate. Our real property, our real estate, if it's just owned just in our name, then it will have to go to probate. So how do we avoid probate? And most people want to avoid probate, and the court really wants you to avoid probate. They want you to be proactive and have these documents in place so that you won't have to go to probate. Now, in regards to our financial assets, and that's our bank accounts, credit unions, our 401ks, any stocks or bonds, we want to put a beneficiary. Sometimes it's called pay on death, transfer on death, and trust for. Different financial institutions use different terms, but you want to put a beneficiary on it. You don't want to add anyone as a joint owner. Remember, if you add someone as a joint owner, they can walk into the bank at any time and they can take your money out. If there is a creditor, the creditor does not look at who's putting money in, they look at whose name is on that account. So we suggest that you not put joint owners unless it is a spouse or a life partner, but that you put beneficiaries on it, because upon your death, all your beneficiary is going to do is take your death certificate into the bank or notify the financial company that you have died, provide your death certificate, and that money will be transferred over to you, and it will avoid probate. In regards to our tangible assets are all our stuff, everything that's in the home. And we know that we can't register that in anyone's name, and most of the time it's just sentimental. I give the example with my grandmother. My grandmother loved hats, and she would, wear a fancy hat to church every Sunday. At my wedding, I got a picture of the two of us, and she has a beautiful hat on. Those are sentimental tangible assets, and it's not registering in anyone's name. And what my aunts and my mother did upon my grandmother's death, they just brought all the hats out into the dining room, and we picked out hats that we wanted. And so those are our tangible things. And when we do a last will and testament, we attach what's a list. And on that list, your personal representative, you can make sure that your personal representative know that you want that tangible asset to go to a particular person. But our major tangible asset that has the most value is usually our car. And if we want to avoid probate with our car, we have to make sure that we have beneficiaries on everything, and the only thing that's left is that car. So if we want to transfer that car upon our death, and it is paid off, it has to be paid off, your personal representative can have that car transferred at the Secretary of State. There is an affidavit that can be completed that just basically says there's nothing in the estate to be transferred other than that car, and that car can be transferred, and it would avoid probate. So how do we avoid probate in regards to our real properties? Our homes are the foundation of our family generational wealth, and we want to ensure that we can transfer our homes to our next generation. And the way we do that is by executing a document that's called a ladybird deed. It allows your home to fall outside of your estate, and it transfers immediately upon your death. So basically, what is a ladybird deed? It is really a type of quitclaim deed that we commonly use in Michigan estate planning, and it's a means to forego probate. It is essentially just putting a beneficiary on your home. Now, during your lifetime, you maintain ownership. You can do whatever you want with your home. You can sell it, you can rent it, you can refinance it, you can do whatever. However, after your death, it would automatically transfer to the person you want it to go to. My husband and I, we have 2 children. They're 20 and 22. We have a ladybird deed. So upon both of our death, we have put in place that the home would go to our 2 sons to do what they want to do. And that way, we are transferring our generational wealth. That's the purpose of what we want to do with our estate. We want to make sure that our children are able to have that generational wealth. Now, if you went to a private attorney to have a ladybird deed drafted, it could be at least $500. But with these 2 programs that we are telling you about, we can do that free of charge. Okay, some of the benefits of a ladybird deed: it is going to protect our family homes and maintain generational wealth. We're going to retain control over our property during our life. They have no ownership of our property during our life. It avoids probate. It avoids what we call Medicaid recovery. If you happen to be 55 years or older and you receive long-term care benefits, or the person goes into a nursing home, when you file that Medicaid application, it basically says that if you have any assets that's not protected by, say, a ladybird deed, that the state of Michigan wants to be reimbursed. And the way they are reimbursed is if that home is not covered by a ladybird deed or jointly owned by another spouse, then they're going to ask to be reimbursed. And the way they are reimbursed a lot of times is that home is sold and you pay back that money if you receive those benefits. Another thing is it avoids the pitfalls of joint ownership. When you apply for Medicaid, they're going to look back 5 years to see if you added someone to any of your assets, say your home. And if you have, you're going to be penalized, and that's called Medicaid divestment. Also, the ladybird deed doesn't cost thousands of dollars to have drafted, and we draft them all the time. We record them at the Register of Deeds. It costs $15 just to record them at the Register of Deeds. Under the City of Detroit program, they're even picking up the recording fees or anything that's associated with this. So I know we are on a time limit, so that concludes, and I do apologize for moving fast, but I know I want to be respectful for your time. Okay. Well, we actually have another presenter who's going to come and talk about trust. And then if we have a couple minutes, then we can answer any questions, or we're going to stay afterwards and answer any questions that you guys may have. This is Aubrey Ortel.
All right, so as Irma stated, I am going to briefly cover trusts, what they are, how they work, and I know this is going to be a lot of information, but we do want to just remind you all that the purpose of this today is to give you an introduction to the documents, to provide some education on this. We want to make it very clear that this is not legal advice yet. If you want legal advice about your current situation, we need you to fill out that intake sheet in your folder and turn it into one of our team members, because the advice that we want to give you is going to be tailored uniquely to your situation, what assets you have, okay? So now moving back to trusts, what they are. Most of our estate planning clients, we have found, actually don't need a trust. There's a lot of misconceptions about how important they are, and we've found that most clients can have the same protections and the same goals accomplished through the other 4 documents that we've already talked about today. And we'll talk about why that is a little bit too. And another misconception is that if you have a trust, you don't need a last will and testament. And that's just not true. It really depends on the language in your trust, and we want to make sure that all of your assets are accounted for. So we want you to work with an attorney on making sure that that's provided for. So what exactly is it? A trust is essentially a contract. And on one side of that contract is you, the creator. And in this context, you're called a settler. That's the legal term for it. And on the other end of that contract is a person that you appoint. They're called a trustee. And so what you're doing is essentially transferring legal title of your assets into the trust, so it's not in your name as an individual anymore. And that trustee then has a fiduciary duty to safeguard it, to manage it. And that language, that fiduciary duty, is just a fancy way of saying that they have a special obligation, a heightened obligation, to manage it well, to be loyal to you and your goals, and just making sure that that need is met. And there are legal consequences if they don't follow that. And then when a trust is created, it can be one of two things. It can be revocable or irrevocable from the beginning. Revocable means that it could be modified, amended, changed, or it could even be done away with, almost as if it never existed. That document or your trust can stay revocable up until your death. At the time of your death, it automatically becomes irrevocable and can no longer be amended or changed. On the other hand, you could set up the document so that it is irrevocable from the beginning. And with that, you lose a little bit of control and flexibility, but with an irrevocable trust, there are also an extra layer of protections around it. So if you had to work with a private attorney to get a trust done, even a really simple trust, we're looking at about $1,000 to $3,000 just to create the document, bringing a trust into effect. And that does not include the cost of having money put into the trust or assets in the trust to carry out your wishes and your goals. And that trustee who's on the other side of that contract, they're going to be essentially working for you, and they're not going to do that work for free. And so they also will need to be compensated from money within that trust, okay? So briefly, an example I like to give a clearer picture in our head of how a trust operates, think of it like its own small company. Okay, it's completely separate from you as an individual. It has its own name. It has its own hierarchy of how things are controlled. You, the settler, the client, you're like the owner and the founder of that company. You may have some different levels of control depending on the type of trust that's created, but at the end of the day, you're not going to be the one making active decisions about how it's managed and invested. That's going to be the trustee. And so they're going to be that president or the manager of that company. The beneficiaries of the trust are like the shareholders of a company. So they may be entitled to a paycheck here and there, but they are not going to have the power over how things are managed or invested on the day-to-day. And then the terms of the trust are like the bylaws or the rules that the trustee must follow. And again, because there's a fiduciary relationship there are legal consequences if that trustee violates that. Under the City of Detroit program, we are able to help people create trusts under two situations. The first is a special needs trust. And a special needs trust is drafted to protect governmental or community benefits that are available to a beneficiary because of a condition that they may have or a financial status that they may have. And one of the reasons that a trust is drafted in this situation is to make sure that they're still able to receive or inherit assets without disqualifying them from those benefits that they're depending on to live. And then another situation is a family trust. These are most often drafted to protect or pass property to minor children. Anyone who's under the age of 18 is not able to take real property or large financial property, and so trusts are created so that those assets can be managed and taken care of until that person becomes of legal age, or at any age beyond 18 that you decide. So it could theoretically be a stipulation that they need to graduate from college first, or you want them to be 21. There's a number of situations that could play out there. And then there is a misconception that a trust is going to protect your assets from the estate tax. Now, Michigan at the state level does not have an estate tax. There is one at the federal level, but that threshold is so extremely high. If you are needing to worry about that, you would have to have an estate. And I know that we have the numbers for 2024 on the screen, but I believe the updated for 2025, as a single person, your estate would have to be valued around $13.99 million just to be worried about that estate tax. And so for most of us, that's just not going to happen, and that's okay. And if you're a married couple, then that number jumps. And so there are lots of benefits and negatives to having a trust. And of course, as you go through this process with our team, we want to make sure that you understand those. I know that we're running a little bit short on time today, but if you have questions about that, we'd be happy to answer them when we're working with you one-on-one. And again, I just want to share that we strongly encourage you to take advantage of this program now. We're currently only funded to do this work for free until September of 2025. So please consider, if you don't have these documents in place yet, prioritize taking care of yourself and making sure that you've got your documents in place. So if we have any questions, do we have time for a couple of questions? Okay. Okay. Yes. Okay. So through the City of Detroit program, we're only funded to cover trusts in those two situations for special needs or a family trust. Otherwise, it's beyond the scope of what we can do, and you would maybe want to consult a private attorney.
She wanted to know if we would be able to assist with the trust, and we were telling her that the two situations, again, we have two programs that we're working on. One is our traditional grant program, and that traditional grant program is covered by Detroit Area Aging or the Senior Alliance, depending on where you live. And under those traditional grant program, we do not do trust. However, under the City of Detroit program, which we're being funded to assist the residents of the City of Detroit, and if you own a home and you're under that 300 percentile of the federal poverty level, which is about, for one person, I believe in your folder, there's a chart, but for one person it's about $46,000. Under that program, the City of Detroit, we are doing some trust, but we're doing trust in two situations. If it's a special need, say you had someone who is autistic or has some kind of special need, then we would assist with the trust. And also if it is a family trust, which means for minors. So those are the two situations. In regards to referring you to someone, we have a list. We suggest that you contact the State Bar of Michigan, and we also have a list with some other names of some attorneys that we're familiar with that we can give you. But in regards to a trust, you need to kind of, when you talk to an attorney, they want to know what is the purpose of the trust, what are you trying to achieve with the trust. Majority of our clients, they don't need a trust. Majority of our clients, their major assets, just like mine, is my home. So with my home, I don't have any children that are special needs or anything like that, or any minor children at this point. Now, when my children were younger, then a trust would have been something that we needed. But at this point, that being my really only asset, and the ability to just put beneficiaries on any other assets that I have, a trust is not really necessary. But everyone is different. Their situation is different. And we have a question back there. Yes. I have 3 children, and so I'm in the process. I'm going to be whatever document is in this packet, and then I'm going to name on it. Is that possible? I know they said choose one, but none of them like it, so I'm going to offer them 2.
The bird. So
So, the girls. So, is that okay?
So are you talking about for your will, for your ladybird deed? Is that, okay, yes, that's fine, yes. Y- y- Yes,
Another thing, I would suggest that before you do anything, you make sure Uncle Sam is taken care of. Before anything is dispersed, like your will and all that, you know, for money, anything to do with money, make sure, I would suggest that, you take care of IRS, because they'll come back and get it if you don't.
Would you repeat any part of that, because a lot of us didn't hear it?
Oh, I'm sorry, I thought I.
No, that's okay.
so she asked first about if she can disperse her assets to all three children. And that was according to the will, the ladybird deed. And that is yes. I mean, it's up to you how you want to disperse your assets. It's not, there's no, you know, way that you have to do it or you don't, you know, it's up to you. So yes, that is definite. The other question, I don't know if it was a question.
Yeah, I think it was a question, and I think that there may have been confusion when I said my grandmother left the home to one. But she did. She left her home to my aunt, but all her tangible assets was left to all her children. So you can disperse your personal and your real property to whoever you want. And majority of our clients, if they own a home, they will leave it to all their children. Now, one of the things I stressed with them is you need to make sure that they all get along. Because if they don't, there's going to be litigation. There's going to be one person want to live in that house and not pay anything, but say it's my mama's house, and think that they have the right to live there. So you want to make sure that if you're leaving it, that person has the capability to keep the upkeep, and also that the people will get along. In regards to the credit cards or anything, if you have credit cards are unsecured debt. So if you have credit cards and you don't have an estate, if everything passes by beneficiaries, the credit card company is out of luck because there is no estate. So, I mean, that's great that your mom had these once she became disabled, you know, and there is some insurance that you can get if you be a disability that they will pay it off. But if the person dies and everything is left by beneficiary, then the credit card company is just out of luck. It's not necessary that you have that insurance. Okay. Any other questions that we have? Way in the back. Okay. Well, whoever you leave it to, she wanted to know if you can do a ladybird deed if the house is not paid off, if there's still a mortgage. In my current house, it's not paid off. I'm hoping that I'll be years and years from now when we leave it to our children that it is paid off, but you can still do a ladybird deed if it's not paid off. Now, if you die prior to it being paid off, it is still, whoever you leave the home to, they still have to pay the mortgage, okay? It's subject to, that's a secured debt, just like a car is. You don't pay it, they come and take it. So whoever gets the home, what they could do is they could always sell it, pay off the mortgage, and, you know, keep any remainder, or they can just continue to pay the mortgage. The mortgage company don't care where they get the money from, as long as they get the money. Any other? Okay, we got one. Okay, so your mother died without a will, which means she died intestate, which means that you have to probate the estate. And it is so you have to go to the probate court and you have to file a application or a petition to get the probate estate started. And it's really going to depend. I remember I was looking at that tree. If your mom was not married and she just had children, then you're going to look at all her children. All her children are going to take up that estate. And I can meet with you afterwards and talk to you individually about it, but it has to be probated. Dr. Durham, you had a question.
You all talked about capacity. How is capacity defined? Meaning my loved one no longer has capacity.
Do you want me to do it or you?
Oh, go ahead. Oh, okay. So Dr. Duran asked about capacity. How is that determined or defined? So with capacity, it's a legal capacity that we're looking for so that people can create these documents. The durable power of attorney for healthcare and finance, we have to determine whether they have capacity or you have capacity basically by understanding what the document represents, what it has the power to do, what type of powers you're giving up, and who you're giving them to. So you really just need to know about your circumstance, about your situation, and be able to understand what the documents are when we explain it, as well as know what they have the power to do, because you give a lot of duties. As I was explaining the durable power of attorney for finance, those are just some of the duties that are given away, but they're very powerful. They allow you to do and have a lot of access. So we want to make sure that that individual understands what they're giving away and who they're giving it to.
So is it possible for me to have a diagnosis of dementia and still have capacity?
So with the legal capacity, yes. I mean, we would determine how, if you understand, because even if you have a diagnosis of dementia, that doesn't mean that you're not able to understand things. You're not able to, comprehend what we're saying. That doesn't determine if you're able to do the documents, but we do have to go through the assessment and then determine whether you should move forward. And if you can't move forward, then the guardianship or conservatorship would be something that would be next. I'll have Irma add.
So when I usually do an assessment, a legal assessment is different from a medical assessment. And when I do a legal assessment of a client, the first thing I do is I have them into the office, and it's not one of those, who's the president? What day is it? It's usually, hi, how are you doing? Are you married? Who is your, who brought you here? Did you have any children? Making sure that they understand who their family is, making sure that they know what their employment status was, making sure what they owned, asking them questions. So if you weren't able to handle your medical or your finances, who would you want? Who's in your life daily? Who helps you with those things? So it's just a very, laid back conversation. And if they can tell me all those things, and they can understand that they are asking for assistance that someone else handle those matters for them, then I can do those legal documents. Now, I can do those legal documents, and then I can call them tomorrow, and they don't know who those people is. It's at that time. As long as they have capacity while they are drafting, while I am talking to them, and while they're executing those documents, then as a lawyer, I can actually draft those documents and execute those documents. They have to have capacity at that moment that they are executing those documents. Mm-hmm. The gentleman. It's just a title. Our Lady Bird deed, it'll say quit claim deed, because the registered deeds require that you have some type of title on it. Like a warranty deeds, you're warranting that it gives certain types of, I would say, it gives certain types of clarity is saying what you actually, that you are warranting that there is just one owner, that you're warranting that the that the taxes have been paid. Whereas with a quitclaim deed, you're just giving whatever you have. So if I only have 25% of a property, I'm only giving you the 25%. There is no warranty with a quitclaim deed. Now with our Ladybird deed, we just title it quitclaim deed, but underneath it, it'll say pursuant to Michigan Land Title Standard 9.3. And you actually have to read that deed to see what the person is giving you. So ours would basically say that I am the grantor and I grant it back to myself for my lifetime, reserving the power to sell, to mortgage, to refinance, and however, if at the time of my death I still own that property, then it's going to go to whoever I want to leave it to. So anytime you have a deed, you have to read the deed and see what it is conveying, what it is giving that person. And I think.
So the City of Detroit program, to qualify for that one, it's for, you have to be 300% of the poverty level. And there is a chart in your folders, and it tells you the breakdown of what that looks like. So that's for that program. And then there's some other qualifications, like you have to be a City of Detroit resident. You also have to own a home in the City of Detroit. That qualifies you for that program. With our traditional program, you have to be 60 and older and live in Wayne County. And there is no income requirement. So you could have any income at all, doesn't matter, and qualify. Just be 60 and older, live in Wayne. Okay? And I saw one other question. Oh, okay. Anybody else? Okay. Thank you so much.
And again, just as a reminder, if you do want to move forward with our services today, please come up and return that intake sheet, and I will exchange it for a worksheet packet, some homework for you.
Thank you very much. Was that informative? And I think that the last clarification I thought was really important. You don't have to be, for some of their programs, you don't have to be in a poverty level. You just have to be 60 years old and live in Wayne County. So that's important. And you guys are going to hang around a little bit for us? And they're going to hang around, and if you're interested, please fill out the forms for us. Any other questions on anything? I also normally will open up any questions on dementia, issues you might be having with a loved one, that we can add any value for you. Thank you, sir. We appreciate you. We appreciate you. Then our next session is, and let me just emphasize how important this is, if you don't already know. Families, was it Aretha Franklin who died without a will? She had several. She had several wills. So they had to struggle to figure out what worked with that. But there are other people who die without wills, and it requires a whole lot. So once you're given an opportunity to do something in advance, it's important to do it. All right, we're going to say our next session is next month on June. My God, the year is really rushing, isn't it? Again, we're going to do it on the diagnosis for dementia, and we have a neurologist coming from the University of Michigan that will answer your questions. Anything else good for the order? How was lunch? Good. Thank you for coming, and we're going to end this session, yet I have a few more things that we want to do. We have some giveaways, but we don't have to do that online. We'll bring the giveaway stuff up, and we're going to do that. So I welcome you, anybody watching us on Facebook. Should you have questions, please feel free to send us a note at universaldementia.org is our website. And we are a nonprofit, so please feel free to donate any amount to us, because we want to continue with this work. And the Detroit Area Agency on Aging is our biggest partner right now. So thank you. We're going to let it go for now. All right. We're done.